Good afternoon. This is Mark Poerio from the DC office of Wagner Law Group, and welcome to our webinar discussion today, Tightening Up Executive Compensation, 5 Steps for Diffusing Litigation Risks and Better Enforcing Restrictive Covenants. I'm fortunate to be joined by my partner, David Gabor. He's in our Boston office, and in addition to that, he's the head of our employment law practice. And you'll see in a few seconds why I think it's so welcome to team up with him. You know, from the title of our webinar, you'll see that we bring together today two sides of executive compensation. On the one hand, it's kind of the planning and drafting side, and then we're coupling that, which to me makes this so interesting, with the litigation side, which involves not just you know, diffusing claims that are related to benefit plans and stock awards, but also how does that connect with employment-related covenants, such as those that involve protecting trade secrets, customers, employees, protections against non-competition, and then also enforcing those types of covenants. David's going to bring the eye to our discussion of someone who's not just an experienced employment litigator, but he also is a business lawyer working with companies, with his focus being on things like workforce structuring, organization, HR policies, employee conduct, and then at the executive level, employment agreements, negotiation, and issues of that kind. My perspective is more of the draftsman. That's because for 30 years, my practice has focused on really tracking executive compensation trends, tracking litigation involving executive compensation, and then reflecting those considerations in stock plans and awards, deferred comp plans, severance plans, usually at the executive level, and employment agreements. During our broadcast today, we're going to invite you to send emails with any questions you have, as well as to email afterward. On this first frame, you'll see email addresses for both me and David. You can also get a copy of this PowerPoint just by requesting it by email. Finally, after the call, we're going to send you a couple articles of ours that are relevant to the discussion and that we're going to reference. One of them was an article of mine that came out early in the year titled New Year, New Stock Plan. It goes into detail talking about a number of the issues you're going to hear about. There's also 2 other articles I'll mention before we get started. First, Law 360 a couple days ago led off with an article titled hashtag #MeToo Tax Cuts Lawsuits Complicate Executive Compensation. I think that was a good heads up about, in some respects, not only how complicated executive compensation is, but how wedded it is to current events. It reminded me of an article that David and I wrote earlier this year about what employers can do in response to the Me Too movement. That was titled The Front Line in the War Against Sexual Harassment. What we focused on there were, what can employers do to beef up their cause provisions or clawback provisions in relation to trying to encourage honorable workplace conduct. So with that background, we're going to move forward to talk about, claims procedures. And I'll introduce it briefly by saying this, that our whole topic today is, in a way, a nerdy topic. Gets into the weeds of drafting plans, awards, benefit notices. My experience has been this is an area that almost always gets very little attention from employers. There's often a patchwork of plans that each of them has its own assemblage of dispute resolution provisions. And as a result, there's often holes in there in terms of what has been addressed or could have been addressed. At the same time, where we have at different companies focused on putting together really well-considered dispute resolution mechanisms and ones that really are designed to discourage litigation and to support the employer to enforce non-competes and other covenants, we've almost never had employee pushback, certainly not at the time of making awards. So I think that's an introductory way of saying this area is something that, from my perspective, there's a lot of room for protection And usually, if it's done thoughtfully, it's below the radar screen. Now, with that being said, let me let David take it from here in terms of, just claims generally and some of the provisions that we consider at the outset in those areas.
Thank you very much, Mark, and hello, everybody. One of the things to think about early on is, do you have an arbitration clause? Do you want to put in a mediation process? The trend towards alternative dispute resolution is a valid trend. Sometimes disputes that are relatively minor can be addressed through mediation and save a tremendous amount of costs in terms of legal fees, risk, and exposure. In mediation, you control the process. Do you have a claims process in place? How detailed is it? Is it something that actually works for your company, or maybe it worked for a different company that you borrowed it from? Who decides the outcome, human resources or an independent committee? Those are some of the things to think about. And then we get to arbitration clauses. In a sharply divided Supreme Court in a 5-4 decision earlier this year in the Epic Systems Corp. Versus Lewis case, dealt with the issue of class action waivers and arbitration agreements. The Supreme Court agreed with the employer and asserted that such waivers are now legal. Employers will now implement these waivers and proceed to arbitration in a whole bunch of cases. Class action waivers are permissible under the Federal Arbitration Act as well, and they're not illegal under the National Labor Relations Act. So that was the outcome that many employers wanted. Sometimes you really don't want what you wish for when you think about it. And here's something that's food for thought. In some states, it's the employer's responsibility to pay for arbitration. And they would have to pay the fees, at least for the arbitrator and sometimes the attorneys for employees who go to arbitration. Imagine in those jurisdictions, Mark, where maybe you've got anywhere from 20 to 30 to 50 to possibly 1,000 employees in a state where now the employer has got to foot that bill. Maybe it's not what people wanted after all. What do you think?
Yeah, that is interesting. And the way the flip side of the fee is one that I like to see in general, which is that this party that's substantially prevailing pays the other one's costs. That's always been one to me that's worth considering. I think I've liked it because it discourages, vexatious litigation, and at the same time, encourages an employer, if they feel they're right, to persevere in fighting a claim. Now, with that kind of sense of the background, one thing to talk about in claims procedures is a common benefit to employers, which is it forces an exhaustion of remedies before an employee can go to court. And a reason why that's so valuable is a couple of them. But first is that it assures that the employer has a first shot at privately getting notice of a claim and resolving it. And that establishes, a path for a private solution. It bubbles up the disputes internally. We can settle them on a confidential basis. Frankly, over my many years of practice, this has been a really efficient, effective approach where, in some cases, it's been an employer that discovered past mistakes, and at the same time, they didn't want to go to, hundreds and thousands of employees, but they figured that, okay, they're going to get things straight going forward, and if claims arise based on the past, they'll deal with them on a one-off basis. When it comes to claims procedures, ERISA certainly is exacting, as many of you probably know, that there's a regulation, 503 of ERISA, that explains kind of what's the mechanism that's required. That's required for some for some executive comp plans, but when we turn to stock plans, those are not subject to ERISA almost always. There's even a Supreme Court case or a top-level case from California last year that came out to that effect. And as a result, there is flexibility for stock plans to have more streamlined dispute resolution provisions. That's usually the case. But at the same time, having something in place is the logical approach, as opposed to just having silence or, very little for dispute resolution, because then that opens the door for going to for employees to go to court and get de novo review, which is basically no deference to an employer decision. Two things that come to mind quickly on claims procedures. One is, be careful, kind of going to just what David said, be careful what you wish for. If you establish a claims procedure, you darn well better be sure to follow it. There are many cases that we could refer to you, and we'll skip over them in recognition of the time we have today. But if an employer puts together a mechanism such as the Executive Compensation Committee will make a decision, and then as a practical matter somebody else makes it, or the employer doesn't in some other way follow their claims procedures, employees are going to win in litigation, and that will almost always result in de novo review. So putting in place a SMART procedure and then following it is critical. And Mark, now, on the other hand, David, go ahead. Yep, exactly.
Yeah, I was going to add, my experience in court has been that the courts typically look at the language almost like it's a contract, and it's critical that the employer follow the terms of its plan, and it's got to dot every I and cross every T. That's what the court would expect of the employer, and it's a real good thing to document.
Yeah. And do you want to just mention briefly, if there was an absence of claims procedures?
Sure. If there's no claims process, basically it becomes de novo, and the standard in a litigation for an employee would be much easier to meet as opposed to if you've got a process in place and you've got deference spelled out in your plan, then it's very hard for the employer to prevail. The employee to prevail.
Yep, agreed. All right, the next frame as we roll forward is about deadlines for claims. This is a huge area where employers can essentially do a couple things. One is to assure themselves that they get early notice of claims, and then the other side is to have a sunset on how long they're exposed to claims. So we'll talk about what are called internal limitations periods first. In this way, what's possible is that a plan can actually set forth a provision that says if there's going to be a claim under the plan, whether it's relating to a claim for benefits or a breach of like the terms of a stock award or anything that would cause an employee to have to be disgruntled or have a complaint about the plan or an award, that has to be raised within commonly you'll see 90 to 180 days after the initial existence of the claim. And, I think that's, in my experience, been a really effective tool. And we've studied around a variety of different states because state law controls for stock plans, while ERISA at federal law level controls this for ERISA plans. But 90 to 180 days for an initial claim after an event is generally considered to be reasonable and enforceable. Again, what that gives you is a chance to quickly find out about a claim and resolve it. And then also after that period expires, such as, for example, in a change of control or a severance plan and you do a RIF, you know 90 days afterwards whether anyone feels that they've been aggrieved by the reduction in force or some other action that's been taken. Interesting thing, a second part of why to include a provision like this in your plan is that there's really nothing to lose. You put it in the plan, and worst case basis, somebody says it was unreasonably short and they don't enforce it, and their claim, potentially lives on and then has to go through the claims procedures, et cetera. But this is essentially an early notice mechanism that's available. Let's see. David, do you want to go into the external, comment there and then go into the external?
Sure. If I'm going to litigate a claim in this area, I prefer to know sooner than later that we've got a claim that's going to be disputed and it's going to go through the process because I've got a better chance to have the records and the historian. People have a short memory sometimes. So you know, if we're going to get into some kind of a litigation, I want to know, and I want my witnesses to have recollection of what happened, what transpired. I want to make sure the documents are available so I'm properly prepared. Now, on the external limitations period, that typically varies jurisdiction to jurisdiction. There's no typical federal statute of limitations, and they look to the most analogous state statute of limitations. And that might be in some jurisdictions 2 years, 3 years, 4 years. So it's advantageous to know sooner than later what's coming down the pike.
Yeah, and just like an example, the case that comes to mind along this line, there was a Martha Stewart Company case. Barton was the former GC, general counsel there. And that case was dismissed because the plan imposed a 1-year statute of limitations, even though the normal state law limit would have been, gosh, if I remember right, 3 years. So essentially, as long as the shortened statute of limitations is not fundamentally unfair or unreasonable by contract, and as David said, in executive compensation in general, whether it's non-qualified plans or stock plans, it's contract principles that apply. There's a sense that executives should be held to honoring contract terms. So if a plan gives out an award, it's conditioned on agreeing to a shorter statute of limitations than a contract law period might otherwise be, the courts will enforce the shorter period. I'm pretty sure that Ohio has like a 21-year statute of limitations on contract claims. I think New York, I can't remember if New York is 3 or 6, but to shorten those periods to 1 or 2 years really can be material in the sense of getting claims resolved and not having a long sunset on when they come back to haunt an employer.
Right,
so
and
with
of course,
that, yeah.
I'm sorry, and of course notice is key. Make sure that the employee does have notice of this limitation period, and it's a good idea to have that notice given to the employee, and perhaps they've initialed and dated it, and it ends up in their files. So you can show that the employee was well aware of the shorter statute of limitations.
Yeah, that's so right, because in all these areas we're talking about, courts are never going to want to see an employer put a gotcha in front of the employee. So we want to be straight up in terms of what the rules of the game are in all instances. When it comes to forum selection, this is a pretty intriguing area. And as we talk about it, we're going to contrast the ability to require litigation in one particular forum against designating a particular state law and being smart about establishing what the governing law is. But we hear a lot about forum selection. In terms of what's possible, I'm actually going to start us off with a couple notes taken from one of our partners, Barry Salkin, wrote an article titled Forum Selection in ERISA Plans. Similar logic applies to stock plans and non-ERISA plans, except the courts are probably more resistant to it there for reasons I'll mention. But as a general matter, if a plan is set forth and designates a required forum to resolve disputes, it will be presumptively valid in general under ERISA, and it will be honored unless there's a compelling reason against enforcement. You know, these provisions won't be enforced if there's a heavy burden of proof, you know, if the resisting party can show that there's a strong reason like public policy for invalidating the provision. But at the same time, the one premise for ERISA is that you want to have uniformity of decision-making, streamlined administration that's recognized that in the employee benefits world, streamlined administration and consistency of the results is desirable. And as a result, having all litigation occur in one particular court can be reasonably justified. Like I said, outside ERISA, I think state courts can be less convinced by the importance of uniformity, even though the same logic would apply to, for example, a stock plan that has thousands of awards around the country. So forum selection in that way, is something that is a matter of contract, can be put into a plan or award, but it is subject to question under extreme circumstances. David, do you want to talk more on that?
Sure. We had talked about EPIC a few minutes ago, and that's a great example where maybe you don't want to select a forum where the employer has got to pick up the employee's tab for arbitration. It's something to think about. Another thing is that despite the presumptive validity of a forum selection clause, it will not be enforced if the resistant party can satisfy a very, very heavy burden of proof. It was showing that enforcement of the provision would be unreasonable and unjust or contrary to public policy. And it's not enough to say it's going to cost me a lot of money. It's very difficult financially. The showing has got to be much, much greater than that. So it's a tall order, but it has been accomplished by some employees in some situations. Another thing to think about, if you have a very, very harsh forum selection clause and you have a benefit plan, what kind of message are you sending to the employee? Mark, I'm wondering, when you've drafted plans and you're talking with your clients, have you balanced the message that the employee is getting with the benefit of a forum selection clause?
Yeah, I think you're exactly right. The messaging that comes with this is really important to consider, and and I think that is what ends up being kind of a balancing act in terms of, how much more efficiency do you get versus when people do get to realize that you're forcing them, especially if you have like a nationwide workforce and you're forcing it into a distant jurisdiction to litigate, there can be a sense that that's just inherently unfair, even if it is enforceable. And that kind of leads to, the idea of maybe it's better in some cases to focus on what law governs. Because, if you designate California law versus Delaware law, you get very different approaches to employment matters. California obviously being more pro-employee, Delaware generally being more business-oriented. And as a result, from my perspective, what often gets appreciated is, being careful about what state law is going to govern, and then even going further, but to set it up to make sure that you litigate in the court that you desire. I'll give you one idea that, to me, and we pursued this at various times over the years and never had a problem with it. I say it needs to be carefully weighed, it needs to be artfully put together, but we put in plans that if that we've designed a plan, say, to be subject to ERISA or to be governed in all instances by a particular state law. And the reason for that is that, we're putting together, very good benefits for people, and we need to have, a predictability of decision making. And if somebody contests that and doesn't, for example, in an ERISA case, go to federal court, and if they contested whether ERISA governed and said state law governed, they would forfeit their benefits. Sometimes you have in these documents a threat that is out there that is enough to just be a risk to somebody of taking an action and contesting whether a plan is subject to ERISA or not. But if you have a realistic basis for the employer position, I think it very much discourages an employee from contesting at the risk of losing all their benefits. So that's kind of one thought that goes in with that type of an approach. David, anything else on forum selection?
Yeah, I think if you are going to go the route of what choice of law, make sure that you've got a legitimate reason why the law of that state would apply. I have seen, believe it or not, cases where an employer has picked a state where they're not doing business, they have no employees working there, they just happen to like that state's law, and that may not get enforced by a court.
Yeah, it's a great point. I was thinking in the stock plan world, an interesting thing comes up because, so many companies are headquartered in Delaware, and as a result, Delaware law for stock claims and stock plan litigation is often favorable. And let's see, there are a couple cases out there, or maybe more than a couple, but one that I looked at right before the call that just comes right out and says if you've incorporated in Delaware, that's a reasonable governing law when it comes to your stock plans and awards.
Right.
But that is a key thing to consider. Yeah. All right, let's go to our next frame, which is arbitrary and capricious review. As a general matter, the standard of review for benefit and stock award type claims, is going to determine the degree of scrutiny a court is going to apply to decisions that are made that are, they're in litigation because they're adverse to the employee. The highest degree of scrutiny coming from a court is going to be de novo review, which means they're just going to start over from scratch, and the court can look at anything the employer did wrong, and the employer and the court can essentially overrule the employer, and on a 50-50 basis, if it's more likely to favor the employee, rule in favor of the employee. The more deferential standard is commonly, abuse of discretion or arbitrary and capricious. And under that, a court is only going to reject what the employer or decision maker has come up with, in egregious situations. When it comes to this whole, go ahead, David.
Yeah, I was going to say that in a recent litigation I had in Minnesota, the court was incredibly sympathetic with the employee in the case, but we had deference. And because there's deference and we did dot our I's and cross our T's, the court ruled on our side in the case. So it's really, really important that you don't want to walk in with a de novo review because a judge's sympathy could become an issue or a factor in the case.
Yeah, and in the ERISA world, it's pretty well established. There was a famous case called the Firestone case that essentially says if you have arbitrary and capricious review and discretionary decisions built into your plan, the courts will enforce it. You would think that when it comes to executive compensation or like a stock plan, which is usually executive oriented, you would think that if an ERISA plan allowed deferential, arbitrary and capricious review for claims by all employees, that if you have an executive-only type of plan, you would be just as likely or more likely to enforce an arbitrary and capricious review standard. Interestingly, the courts are somewhat split on that. There's a 2012 decision that comes to mind. It was an AIG versus Guterman, G-U-T-E-R-M-A-N, that went into some detail kind of talking about the different splits around the country, with some saying that you had less deferential standards if you're outside the ERISA context. But frankly, there was a decision, there's a few decisions out there that on circuits that are much more convincing logic that essentially say, look, if in an area like ERISA where you're applying trust fiduciary principles, if you can establish arbitrary and capricious deference in those types of plans, you can certainly do it in a plan that's governed as a matter of contract. So going back to David's point earlier, when we're dealing with our executive award plans and litigation, it's almost always going to be contract principles coupled with a sense of, is it fair play that's going to give rise to whether these types of provisions get honored. So let's see. There was a really good decision, by the way, in this whole area in a W.R. Berkeley case coming out of Delaware, which is always a good source, where, just to give you a quote, it says, when a stock option committee is vested with final and binding and conclusive authority to determine a participant's right to benefits, that decision made in accordance with the plan, with the provisions of the agreement, will not be second-guessed by the court absent a showing of fraud or bad faith. It's kind of like David's Minnesota case, I would say, and we do see these types of decisions by and large out there in this area. David, yeah, go ahead.
Oh, sure. One of the other things I have seen occasionally is where sometimes you've got a plan and the language in one part of a plan is inconsistent with another because the plan over time has been amended, but when they made whatever amendment or change to the plan, they didn't go all the way back. So I think it's one of those things where if you check a box today and you go back and look at plans, read the entire plan and just make sure your provisions are consistent and that a third party, arbitrator, a judge, will actually understand the language in the plan to make sure it's clear for them, not just in your particular industry.
Yeah, that brings to mind another thought that's along that line, which is, we'll often have plans and awards that just as David said, they've evolved over time, and in many types of companies, you'll have serial plans. You have the 1999 stock option plan, the 2006 stock option plan, and then et cetera, et cetera. And one thing that's a really effective tool to keep in mind when you're aiming toward consistency is you can put into a new stock award, which again is going to be, if you give somebody a stock award, now they have new consideration, for a promise that they might make. And we have frequently put in a provision that will say, by accepting this award, you're agreeing that not only your rights under this award, but all your prior awards are going to be governed by these new claims procedures or by the new plan document. And in that way, in some respects, achieve a roll forward so that you can take the best practices of today and apply them not just to the current award, but to other awards that are encompassed. The key, again, being it has to be straightforward, and this can't be a gotcha as much as it's something that's put on the table and someone is agreeing to it.
You know what? The benefits people in the companies are going to love you for that one, Mark. They can actually administer that kind of plan instead of trying to keep track of 6, 7, 8 different plans, which is a nightmare for them.
Yeah, there was a case about a year ago, ADP versus Lynch, where the Third Circuit looked at ADP's web-based system for issuing stock awards. And I like to refer to it because essentially there were 4 steps involved that a court said, you know what, ADP, you had a web-based system for stock awards, and it was straightforward. And I'll just give you a sense of what the steps were. Employees went to a web page where they were able to look at award documents. They could print a PDF of the award documents. At that point on the web system, they checked a box that said, confirmed that they had read the award documents. And then finally, there was an affirmative accept grant or reject grant button. And the Third Circuit, when it looked at this, said, hey, when somebody hit the accept button, that, in the words of the Third Circuit, sealed the deal to bind them to the award agreements, and in that case, a non-compete agreement, because basically the awards were contingent on a non-compete. So in this case, what ADP accomplished through the web system was to basically seal up enforcement of non-competes through a web-based process. So again, I think being smart about what's put together in the award agreements, and then making sure you can articulate that employees had notice, as including through access to awards, is the smart move. Speaking of smart moves, let's move to enforcing covenants. David, did you have something else there, by the way?
Sure. Actually, that was a perfect segue. If you go back to slide 5, talking about non-competes. We're going back and
Good.
forth.
I made it eventually.
That or I'm seasick. But on non-competes, that goes back to thinking about your choice of law. Because when you deal with restrictive covenants like a non-compete or a non-solicitation, the rules are different in each jurisdiction, and sometimes it might be different in a city within a state. So you do want to take some time to familiarize yourself with what the rules and non-competes are where your employees are located. And many states, Massachusetts included, has just went about changing the rules on the non-compete agreements. So I think it's a good idea to take some time and say, all right, we've got people in, let's say, for example, Illinois, and Illinois's got good language for employers in non-compete agreements or non-solicitation agreements. But the general principle is that they need to be reasonable in scope and time. So, for example, 1 year versus 2 years or 3 years, and can a person work at all in a field, or can they only not work in a certain geographic area? You don't want to be overreaching as an employer in a non-compete agreement, but by the same token, you also don't want somebody who's got proprietary information out there competing against you. Mark, you want to jump in a bit on this?
Yeah, because David's the man when it comes to putting together these, what I call them, the restrictive covenants. I even call them loyalty covenants, because they're not just going to relate to non-competition, but it'll be non-solicitation of customers, non-solicitation of employees, could even be non-disparagement, to just try to make sure that someone that you've trusted at an executive level is going to be loyal to the company when they've been paid well. And, on the one hand, we put together these covenants, and the real challenge in many instances is that when there's a violation, it's almost, kind of common law that employers don't enforce them. And the real kind of hammer behind the enforcement is often going to be some type of forfeiture or clawback right that an employer has. I think language is kind of interesting in this context because in some respects, the word clawback is really popular both in Congress through, you saw whether it's in Sarbanes-Oxley with the clawback rule or in the Dodd-Frank Act, there's a whole section about clawbacks. And it's just because it sounds mean and tough, and when it's applied to a wrongdoer, it just sounds like, yeah, let's claw back everything. Interestingly, clawbacks are very seldom successful or enforced, and much more likely to be advantageous for the employer is a forfeiture, which I would call it through like a holdback. That, take a simple example, we would have paid $1 million in cash today, but instead we're going to pay $500,000 today, and we're going to hold back $500,000 until after somebody terminates employment. And if that's the holdback, that ends up being, an incentive for the honoring of the loyalty covenants that an employer might want to put together. So even though the headline grabber is the clawback, I think holding back and having forfeiture restrictions apply is a much more effective tool. David?
No, that makes really good sense because what you're doing basically, if you defer a payment and tie that to the end of the non-compete or non-solicitation, that can work very well for you. And I think that's a perfect solution in that situation whenever that's possible. What happens, by the way, is if you are overly aggressive in a non-compete, especially, for example, a person who really doesn't have proprietary information or a person is not going to be able to make a living, some states might use something called a blue pencil, and they might redefine what would be a reasonable scope for a non-compete. In some other jurisdictions, you may end up with an invalid non-compete agreement, and that doesn't do you any good. Mark, did you want to talk about the Velvet case?
Yeah, well, what I'm thinking of there, the Velvet Cliff, the Velvet Fist and the iron versus the Iron Glove is a choice that employers can have, which is if you're going to impose forfeiture restrictions, are you going to only impose them on future awards, which is kind of like a below-the-radar screen way to do it, or are you going to be harsher and actually put it together in a way that says this is not, this new forfeiture risk for joining a competitor or disclosing trade secrets applies not only to your current awards, but a look back to past awards. And it's going to the messaging that goes with it. I've had, in different instances, boards consider that, look at it. I've had executives hear about it and be really upset. And I've had boards at the same time say, darn it, we don't care if people are upset. We do not want to pay people well and have them compete with us. So we are going to have a look back and, have our new forfeiture rules apply not just to new awards, but past awards. Now, go ahead, David.
Okay, I was going to say, is that the Judge Poerio rule?
Yes, yeah, exactly. Well, that's kind of like the choices in this area in terms of design. Exactly right. Now, there's going to your point, David, about overreaching and blue penciling. There's a case that just came out of Kansas, Lawson versus Spirit Arrow, which is pretty interesting because there, a former CEO of the company is making a claim or just made a claim for $50 million of withheld retirement benefits and stock awards. What's pretty interesting about it is over the course of the former CEO's career, it looks like he did a great job, turned around the company. They actually negotiated a retirement agreement in 2016. They negotiated a non-compete agreement to extend the company has a protection by 2 years. And then within that new agreement, they said, what's the competing business? They started off the language, I'll tell you why in a second this is significant, but they started off by saying, we are engaged in this business. Well, long story short, the CEO retired, he joined another company, and then Spirit said, aha, you've lost $50 million because this is a competitor. They go to court, and what does the court say? No, you said the competing business was defined by we are engaged, which means an actual business you are in now, which is a narrow phrasing. And as a result, the court said it was very, it was reasonable for the person to have gone to this other company, and there were no allegations that the other company was in the same business. So I think the moral of the story is, it's kind of a tough line to draw when you put together these provisions. You want to protect a legitimate employer interest, and at the same time make sure that it's not overly broad. But to be too narrow is something a company can regret. So that's kind of, just again, what factors in on the covenant side, which is, on the one hand, define it well, and then on the other hand, make sure you figure out what it's going to apply to, because you want as much at stake as possible to encourage someone to strongly consider it before they violate. I know in many cases I talk to individual executives, and David, I'll be interested in your view, but when they tell me they've got, that they're stuck with a non-compete with a forfeiture provision for pay or benefits, and that non-compete restriction looks like it's reasonable, almost always the executives back off and figure a way that they're going to take a low-risk approach. How about you, David?
Well, there's another thing they can do. I agree with what you're saying 100%, but there are times where you can consider ADR, alternative dispute resolution.
Mm-hmm.
You have an opportunity to go to work in another business. Be upfront. Advise them that you are going to consider this job, but let's work this out. And maybe we can come up with a way that we can peaceably coexist with one another. But by being upfront, you're showing that you're being transparent, you're trying to do the right thing, you're being honorable, and you're approaching the employer in good faith. So in that instance, if the employer says, no, absolutely not, you're not going to get anything, you can't work, and you're in front of a judge at some point down the road, some judges may not take too kindly to that position adopted by the employer. So that is another thing to think about. Yeah,
well said. And I had advanced this to the best practices, so I guess what you just said fit right into that category, so that was a good segue. Another, one thing I put down with a question mark here is universal provisions and procedures. And it's for this reason that, at the executive level, there are, very frequently a variety of different plans, awards, benefits, and very frequently they all have different claims dispute resolution provisions with them. And I've had situations where it is just a really painful, expensive quagmire for an employer to get into when all of a sudden they're trying to say either somebody's forfeiting for, competition or being terminated for cause, and what are the mechanisms that the employer has to follow to make sure that's, kind of to close the loop on all that. And in those instances, I think it's, often been worth considering from my perspective, wouldn't it be better to just have some uniformity and try to trend in that direction? And one way to do it is certainly to just have some, procedures that just will always apply unless there's a specific exception in a plan. So that's kind of what that thought is in terms of, aspirationally what could be a best practice. But David, I'll welcome your thoughts on that as well as other litigation precautions that might be worth considering.
Sure. Let me jump into a different area. I think that's a great point you made, Mark, but I wanted to talk about when you've got non-compete, non-solicitation agreements, and you're talking about people at a high level in a company, then you get into the question of when is it a good idea to have an employment contract. The general rule of thumb is that everyone's an employee at will unless they've got a contract, and then the contract will define the terms of their employment. So you may want to make sure that a person is vested in you and will be with you for some period of time. And one of the mechanisms is to have certain benefits that vest over time that encourages a person to stay longer. And in those instances, it may not be necessary to have a contract with a length of time provision built in, because the carrot is the benefits that are vesting in 1, 2, 3, 4, 5 years. But when you do get into a contract, they're no longer an employee at will, and now you can no longer terminate employment for any reason or no reason at all. Now you look at the contract, and where I get into a lot of disputes and issues is for cause. What is the cause? When can a person's employment end? You know, if there is a cause, how do you resolve that? And that may be one of those situations where you think about having a mediation or an arbitration over whether or not that employee's employment can be terminated based upon what they've done. But then you get into another area which becomes a real problem. Let's say we've got an employee who is at a high level, is not doing a great job, maybe is missing meetings on a regular basis, is showing up late, it's delegating things that person should be doing, isn't following up enough, but you want to be nice and you're an amiable and you're not documenting it. So you really don't have a record. The person's late, the person's missing a meeting, they're delegating what they should be doing themselves, they're not doing the job you asked them to do because you're an amiable. You've got to really make sure that you're keeping a real strong paper trail so that if you do decide that you're going to come and see me as an attorney, and for those of you who remember the honeymooners, you really don't want me going into court and when the judge is asking me for whatever documentation I have, I'm doing my best Ralph Cramden saying, humna, humna, humna. You don't want me doing that. You want me to go in with clear documentation. So it's just a reminder, please, if you're going to have a person working with you and you've got, you know, an exit strategy which includes, you know, termination of employment in this kind of situation for cause, please document and have that paper trail for me.
It's funny because when we do talk about terminations of employment, what came to my mind is also going to involve a trip down memory lane, not as far back as the honeymooners though, but when I look at release agreements, and especially at the executive level, you know, I think a trap that I've seen employers fall into at times will be to say things like, you know, you will receive the performance-based bonus determined under our incentive plan, you know, when the bonuses are paid next year or things like that. But, you know, from my perspective, I much prefer to just lock in a number so that we don't have a derivative claim come out where the person says, you screwed me on how you calculated the bonus. And going back to my memory lane, some of you might remember I think it was the 72 Dolphins, Miami, but there was a player named Mercury Morris. And he settled his retirement claim with the NFL in 1991, and 21 years later, there was an article that said he had finally resolved his settlement terms because the agreement with him in 91 said he would receive full and appropriate retirement benefits, but it took him 21 years to figure out what that was. So that's, you know, just an anecdotal way to say, you know, man, if you just lock in a number and say, we'll pay you $50,000 in full satisfaction of your stock awards or something like that, it can often just be a great way to avoid future arguments that are otherwise expressed, you know, such as we'll pay you the in-the-money value, and then you could be arguing about, well, you know, when was it calculated or what does it mean? So personally, I like hardwired numbers to the extent we can get that in there.
Great point, Mark. I could add, since you're talking about severance agreements, be careful in some jurisdictions, confidentiality agreements might be illegal in certain types of cases. For example, where there's been a claim of sexual harassment that got filed with a state agency or the Equal Employment Opportunity Commission, that's a trend that may grow into more and more states over the next year or two. So be careful if you're in a state where the employee is working and they're somehow involved in some form of a sexual harassment claim that's been filed with an agency or in court, there may be a prohibition regarding confidentiality in a separation agreement.
Yeah, along that line, I just worked with Bloomberg to update their executive compensation library for checklists, and one of them that we put together deals with claims releases. And if anyone wants to receive that, just send us an email. But adding one other thing that to me is often overlooked but really material, it's going to be anytime you're modifying an award or figuring out a way to go forward, either not necessarily in a release agreement, but often it's just a stock award where you want to change some provision somehow, make sure it's supported by consideration. I had a case where, we had restricted stock awards, and for a variety of reasons, the employer needed to extend the settlement date for the stock awards, and what they came up with was they were just going to extend the vesting requirement, and then wait a year. But then they started to face employees who said, what do you mean, I need to wait another year and work for this award? You didn't have any right to do that at the front end. And they ended up with enforceability arguments, messaging arguments, and frankly, they took an unenforceable approach because the employees weren't getting anything in a case where they were waiting another year for their awards. So there can be, there's certainly enforceable avenues to address executive compensation, but anytime it's changing, there needs to be legal consideration for it. So, David? Yeah.
Yeah, that's a great point. Yeah, hey, Mark, do you have a top 7 list about this?
I was hoping you would ask.
Surprise.
There we go. David and I put our heads together, and we're trying to think of what would be the takeaways that you could hear from this call on a general basis and move forward. And certainly, the first one that we put down is, things really do change rapidly in the executive comp area. I've been responsible for model plans and award agreements for the last 20-some years in my law practice. And I can tell you that regularly we are updating those documents for changes that reflect litigation, in the executive area. One example right now is director compensation. Having a plan provision that deals with a shareholder-approved maximum amount can be huge in terms of avoiding shareholder derivative risks. But that's just one example. But in general, updating is really smart. In many cases, we're dealing with tweaking of documents, but nevertheless major changes, that can be benefits, such as put in place the internal limitations period to get quick notice of claims. I think we've covered a lot of different items that employers could address during this call because we were trying to be, thoughtful and give you a menu of what could be addressed. But certainly, from our perspective, you don't want to do nothing because you've tried to do too much. It's better to figure out what's really material to us, what really helps us out, and then get it done. Consistency we talked about in terms of, trending toward that. Getting quick notice of claims and a sunset on claims is really smart. Going to our last 5 items, the precision point to me is something that you'd be amazed if you track the litigation, how much can turn on being precise in litigation. There's a recent case that came out where the employer basically put together restrictive covenants. And the employee had the agreement for a month, and they basically said, you sign the agreement, and effective when the agreement is signed, you will not violate all these covenants. Well, it turned out that a month beforehand, the employee had violated the covenants. But the court said, hey, if the employer had wanted the protection to be retroactive, they should have said it. So again, just being thoughtful and careful in the drafting is important. And, as Dave and I have been emphasizing, to the extent that you are precise as an employer and honor what you said, it'll work. but if it's ambiguous or uncertain, it's going to be resolved in favor of the employees. I see that come up very often in stock bonus or cash bonus plans where something happens that might not have been anticipated, such as an acquisition and the impact. But if the bonus plan has not addressed the ability of the employer to take into account an acquisition, then employees may have greater rights to bonuses than would have otherwise have been, thought to be anticipated. I think culture matters and messaging matters are those last two items that we see as really important because, as much as we might want to discourage litigation or at least, I should say, encourage dispute resolution, in a fast, positive way, we want to make sure that when we deliver any of these messages, it's done with, with a sense of how it's going to impact people. And also, sometimes you want the interim effect of, darn it, if you're going to get a big bonus and compete with us, then you are going to pay and forfeit. I mean, that is a message that some employers decide they want to deliver, and that is possible to deliver.
That's so true. I'm sorry to step in your words,
No, I'm glad you did.
From my perspective, I do a ton of work on things like sexual harassment and training in that area. And what's become real clear to us is the reason why so many women have not objected to sexual harassment, so many people who are witnesses to it have not reported it, is because of the fact that there's a perception they have that the company doesn't want to hear from them. So how do we change that perception? And that is a shift in culture. I think a culture where there's top-down buy-in to what we want this company to be. And let's suppose the company is good already. Let's make it better. Let's suppose it's the employee engagement and morale is average. Let's get it to be good. We can always stand to improve. But the culture starts by top-down buy-in. So when you put together plans and you're treating the executives well, and you keep that in mind in the type of plan you put together and the language in the plan and the message that comes with it, and you continue that same pattern down through everything else, including your manuals, including your training, then I think that the company's got a much better chance to be successful, and you're going to have executives who are committed, loyal, and will be with you for a much longer period of time.
Yeah, well said. And you'll see, the guiding principle at the bottom of that page, is, I find that in the executive compensation world, there's not much that advisors agree on, but this is something that is generally recognized as a truism, which is, we really, we're willing to pay people well for performance that's good and behavior in the workplace that's good. But, we don't want to be faced with bad actors in the workplace or bad results or, or violations of non-competes and covenants afterward. So I think from my perspective, a smart company puts those two together. We can go to our final remarks, David. We mentioned already, and the next frame after this is going to, again, have our email addresses for questions for anyone that might have them. But I welcome you, David, to pull us together, and then we'll move on.
Sure, thank you. From my perspective, where I see the most problems arises when people rush, they're not aware of a change in a statute or a process, which leads to either a portion of a document being invalid in that jurisdiction or inconsistencies. But I did want to also mention that we have some upcoming webinars, and I'm doing one which is next week, September 5th at 1 p.m. with a couple of colleagues, Kim Svoboda and Amanda Scott, identifying, securing, and developing and managing great talent. If you're interested in learning more about it, send an email over, and I would be happy to forward an announcement on it. Mark, do you have any webinars coming up?
Yeah, a couple. One of them is going to be at the end of September, the 26th, focused on executive compensation issues faced by not-for-profit boards. And we're aiming there not only at employees and executives of not-for-profits, but also board members. Oftentimes, you have individuals who are serving on boards as volunteers, and they're responsible nevertheless for approving executive compensation. So we're going to focus on that issue there. And then I've got two other talks relating to merger and acquisition issues relating to executive comp and employee benefits. Those are limited to memberships in a couple organizations, the ABA and the American Benefits Council. But if anyone wants information, like a copy of the PowerPoint or information about M&A issues, we'll certainly be glad to share that. And let me move us forward to what we really want to end with, which is a thank you for anyone who's joined us today, and an invitation to you with any questions you might have about the subject matter to contact either David in Boston at his email or phone, or myself, Mark, in Washington. So with that, I want to thank David for all he contributed, time and energy, and to everyone who would have participated today. So we'll look forward to the next broadcast. Thank you, everyone.
Thank you. Take care.
Bye-bye.